and welcome to Doing Business As, the small business law podcast from Tracktown Law. My name is Jared Hight, and I am the founder of Tracktown Law and your host for today's episode. Tracktown Law is a virtual law firm helping business owners across Oregon and Idaho get legally sound, tax-aware, and practically protected. Whether you're forming your first LLC or tightening things up after years of growth, this podcast is here to help you understand what matters and what doesn't without the noise. Today we're talking about business bank accounts. Not exciting, I know, but I can tell you this. Failing to set up your business banking correctly is one of the fastest ways to undermine your LLC, and one of the most common mistakes small business owners make. So if you're still using your personal checking account to run your business, or you opened a business account but never really separated things, this one's for you. Before we dive in, the usual reminder, I'm a licensed attorney in Oregon and Idaho, but this podcast doesn't create an attorney-client relationship, and nothing here should be considered legal advice for your specific situation. That said, let's talk about why your business bank account is not just a convenience. It's a legal boundary. When you form an LLC or a corporation, you're creating a separate legal entity. That's the whole point. It's supposed to be distinct from you. It can own property, sign contracts, pay taxes, and, this is key, shield your personal assets from business debts and liabilities. But that protection isn't automatic. You have to treat your business like a business. If you mix your personal and business finances, the courts and the IRS will treat you like one and the same. That's called piercing the corporate veil. And when that happens, your LLC's liability protection goes out the window. Setting up a dedicated business bank account is the simplest, most basic step toward showing that your business is real, separate, and compliant. So what happens when you don't? Let's say you're a wedding photographer in Eugene operating as an LLC, but you take client payments through your personal Venmo account, deposit checks into your personal bank account, and use one debit card for everything: meals, gear, groceries. You're not doing anything shady. But if a client sues you or the IRS audits you, it's going to be very hard to argue that your business is distinct from your personal finances. And in court, that distinction matters. If the court finds that you've commingled funds or failed to observe basic formalities, they can hold you personally liable for business debts, breach of contract, even damages from a lawsuit. This can go sideways with surprising speed. Imagine a two-member LLC in Boise running a small digital agency. One partner handled client billing and just deposited everything into his personal account for convenience. They had no shared account, no central record keeping, and no paper trail between income and expenses. When they were hit with a contract dispute, they lost the liability shield completely, and both members ended up paying the judgment out of pocket, all because they never opened a proper business account. So what does proper mean? It doesn't have to be fancy. It just needs to be clearly and exclusively for the business. You want a checking account in the name of the LLC, not your name, linked to your employer identification number, not your social security number. You'll typically need your LLC formation documents, your EIN confirmation from the IRS, and your operating agreement. Most banks will ask for all three. Some online banks are more lenient, but traditional banks, and especially credit unions in Oregon and Idaho, will expect clean paperwork. Once you've got the account, use it consistently. All income goes into that account. All business expenses come out of that account. Don't use it to pay your mortgage. Don't deposit client checks into your personal account. Don't swipe the card for your kids' soccer cleats. Keep it clean. And yes, this applies even if it's just you, even if you're a single-member LLC, even if the income isn't much yet. The more you treat the LLC like a real business, the more others, like the IRS and creditors, will too. This is also where you start laying the foundation for professional bookkeeping. Once your revenue picks up, you'll want to use software like QuickBooks, Wave, or Xero to track income, expenses, mileage, and more. A clean bank account makes that process 10 times easier and makes tax time a whole lot less painful. It's also important if you ever want to bring on a partner, apply for a business loan, or get audited. Lenders and tax agencies will look at your financial separation as a sign of legitimacy. If it looks like you've been running everything through a personal account, they may assume the business is just a hobby, or worse, a liability risk. Some clients ask if they can just open a second personal account and use it as if it were a business account. The answer is, Not a good idea. It might be better than nothing, but if the account is in your name and not the LLC's, you're blurring that legal line again. The IRS won't like it. Neither will a judge. You also miss out on basic business banking tools, like merchant services, mobile check deposits under your business name, or building business credit. Those things require a real business account tied to your entity. And then there's fraud protection. Many business accounts offer better protections against unauthorized charges and better dispute resolution policies than personal accounts do. That's not legal advice, but it's something to ask your bank about. What about credit cards? If you can qualify for a business credit card in your LLC's name, that's great. It's another layer of separation. But many small business owners, especially when just starting out, will need to personally guarantee a business credit card. That's fine. The key is still using the card only for business expenses and keeping the record trail clean. Here's one more real-world example. A small bakery in Southern Oregon formed an LLC but never got around to opening a business account. They used personal cards and reimbursed themselves as needed. When one partner left and asked for a payout, there was no clear way to calculate ownership value. No balance sheet, no profit tracking, no separation of business and personal expenses. What could have been a graceful buyout turned into a dragged-out mess, with attorneys arguing over grocery receipts and utility bills. A proper business account could have solved 80% of the confusion up front. Bottom line, if you've formed an LLC, treat it like one. That starts with a clean, dedicated business account. And if you haven't opened one yet, make that your next move. You don't need a ton of money. You don't need a fancy business credit score. You just need the right paperwork and a commitment to separating business from personal. Your future self and your tax preparer will thank you. If you want a little more detail, or if you'd rather read than listen, head to the companion blog post for this episode at tracktownlaw.com. It breaks this all down in written form and includes a checklist of what to bring when opening a new account in Oregon or Idaho. In our next episode, we're going to talk about how to pay yourself from your LLC. Should it be a draw, a salary, a distribution? What's legal? What's smart? And what'll get you in trouble? We'll cover all that and more next time on Doing Business As. Thanks for listening.